Good afternoon, everybody. Just as more and more people join us for this session, I just want to do some introductions. Welcome to this session with the Heritage Digital Academy on what is copyright and the Creative Commons. My name is Thomas Hood. I am the Intellectual Property Officer at Naomi Corn Associates. And the presenter today is the one and only Naomi Corn, who is the CEO and founder of Naomi Corn Associates. She is one of the UK's leading experts in copyright, data protection and licensing, and her particular expertise that she's doing in her PhD at the moment with the University of Edinburgh is analysing the impact of Brexit on the management of Orphan Works, which is a specialist area of copyright. And without further ado, I will hand on to Naomi.
Oh, that's wonderful. Thank you very much indeed, Thomas. Very kind indeed. So a very warm welcome from all of us to the Heritage Digital Academy webinar, What is Copyright and Creative Commons Licenses? We're absolutely thrilled that you could join us this morning. The session will probably take about an hour or so. My intention is to give you an overview for about 45 minutes and then open up the floor for questions, which will be moderated by Thomas. Please do keep your questions coming in. If you could use the Q&A function, or you can use the chat box for your questions, and we'll make sure that we'll deal with as many as possible at the end of the presentation. To keep you on your toes, I have embedded this presentation with a couple of polls, so you'll have an opportunity to interact as we go through today. Do introduce yourselves to each other in the chat box. It's always lovely to see people from different organisations and also with shared concerns and interests as we go through. So we're looking at about 60 of you joining us today, hopefully from all over the UK. I'm going to make a start on the presentation and give you a sense of where we're going. And actually, this is already demonstrated by the terms of use of our presentation. The content can be shared under the terms of a Creative Commons Attribution license, which means that you can do whatever you want to the presentation as long as you credit us. Please be aware that there is third-party content in the presentation, and you will need to check the terms and conditions specifically with regards to any third-party content you find in our presentation, which may vary from the Ccpy statement I put. Okay, so these are the topics we're going to be covering today. I'm going to be broadly mapping out intellectual property rights and introducing copyright within the broad IP context. We're going to be looking at the benefits of open licenses. I'll be introducing to you the different types of Creative Commons licenses that are available and what they mean. We'll then look at how you can select the right Creative Commons license for the work that you're wanting to make it available under. I'll be mentioning the National Lottery Heritage Fund and its Creative Commons attribution requirements, what that means for you. And then finally, we'll be looking at how you can find Creative Commons licensed content that you can freely use. But before I go any further, I wanted to introduce ourselves to you. If you haven't met us yet, we are very much specialists in copyright and data protection, particularly for public sector organisations and very specifically for cultural heritage organisations. Next year, we'll be celebrating our 20th year in business. And during this time, we're really proud with our track record in the support that we've provided right across the sector, whether this is through our charge for services such as training or consultancy, or indeed through the numbers of people that have accessed our webinars, our free resources, and our newsletters, blog posts, social media interactions, etc. And a little snapshot of who we are and what we've done. We've been particularly busy during lockdown and tried to create more free content that you can use freely under the terms of a Creative Commons license than ever before. Roughly speaking, we've created 26 free resources since March 2020, over 50 blogs, and we have, as you can see, regular high numbers of interactions with our content. Please do check out our website, and if you go to the resources page, you can find out all the different types of resources that we've created that hopefully will be of help to you. Obviously, there's a lot of materials as well that are available which discuss in detail copyright and particularly Creative Commons licenses, are themes of today. And I will be referencing and signposting at the end of this presentation places you can go to get the sorts of answers you're looking for. Any of you that have met me before know that I'm very honest with you about how much I can do, whether it's in a day's training, half a day's training, or in a webinar such as this, which lasts for about 45 minutes. And so my main intention today is to highlight some of the key high-level principles that underpin copyright law and also Creative Commons licenses. And by doing so, hopefully provide for you a sense of the right types of questions and issues you need to be thinking about. And therefore, hopefully with the resources I'm going to be signposting to you at the end of today, you will have the right question, and then you'll go with that to hopefully an authoritative source to get the answer that you need. And if I can achieve that in 45 minutes, I'll be very pleased indeed. So let's start our journey and look at the broad landscape. What are intellectual property rights and where does copyright fit? So very much with the perspective of the big picture here, intellectual property rights broadly protect fruits of the human mind. And so if you want to think about anything that's created by a human being, whether it's an invention, a new endeavor, a creative work, all of these have the potential to be protected by intellectual property rights. And I've used the term very deliberately by a human, or really the essence is a natural person, because currently intellectual property rights do not protect anything that's generated by an animal, vegetable, mineral, or perhaps more specifically artificial intelligence. This is an ongoing discussion. The UK is trying to lead the way. They just closed a major consultation looking at IP and AI, so do watch this space. There's also some very interesting work that's been done by Professor Ryan Abbott, who's been looking at the relationship between AI and IP. But going back to what we know intellectual property rights protect, generally speaking, it's an intangible property right that behaves just like property. You can buy, you can sell, you can bequeath, or you can rent, and we use the term license here, intellectual property rights. And there are a number of key family members of the intellectual property rights family. I'm going to be summarizing a few of them for you today within the context of the cultural heritage sector, which is the primary focus, and very much start with copyright being one of the main members of the intellectual property rights family that most of us will interact with. Now, copyright does not require registration. It's an automatic right. The duration, as stipulated within the Berne Convention, which is one of the most important international treaties outlining key principles of copyright, requires that the duration of copyright in each country that signed the Berne Convention is at least lasting for the life of the author plus a further 50 years minimum. The UK is amongst a number of countries which actually grant the duration of copyright to be the lifetime of the author plus 70 years until the end of the calendar year in which the author died. Essentially, think about it a bit like this. You create something that no one else has created before. It's original, it's not a copy of something else. It falls within one of, in the UK's legislative framework, 8 specific types of creative works, and you, by the virtue of having created something that no one else has created before, gets this exclusive right to copy what you've done and to grant anybody else the permissions to reproduce the work if they so wish to. Now, there's a lot underpinning this. You can imagine this is sort of weeks and months worth of sort of intricate detail that I've summarized in a sentence. But for the purposes of today, I wanted to set the scene and give you that sort of broad understanding. I'll be signposting, as I said, you to further resources you can look up in more depth about this. But it's a very, very important issue, legal compliance issue for cultural heritage organizations, and covers a huge array of different types of activities. We'll look at those in a moment. What I also would like to say about copyright for now is that whilst it is an exclusive right to copy, it's underpinned by a series of balances which are hot-wired into our legislative framework that allow certain types of uses of copyright works within certain contexts. And these are referred to as the fair dealing exceptions, the exceptions to copyright, which will include within the context of cultural heritage organizations, quotation, preservation copying, use on dedicated terminals. They are very precisely worded. And if you want to find out more about the exceptions to copyright, which are important to cultural heritage organizations, we have written a guide as part of the suite of guides we've produced as part of this project. Please do look on the Charity Digital Heritage Digital website for the exceptions guide that we produced about 18 months ago, and that will give you a lot more information about this very important topic for our sector. But a bit more about the types of cultural heritage related activities that involve copyright to show the extent of how far we interact with copyright on a day-by-day basis. So you've got the list here, but really in summary, any type of activity that involves content creation, commissioning, sharing, and publishing, okay, you can see the whole list there, will involve a copyright decision at some point, even if it's just to eliminate the fact that there is no copyright in the work you wish to use, or that you've dealt with it perhaps by a suitable contractual agreement. It's still an issue that we need to think about. And in fact, clearly demonstrates that copyright goes to the very heartbeat of what we do in the cultural heritage sector. So, carrying on our journey, this is really the first point where I wanted to engage with you and give you a chance to test your knowledge and find out from you, how old do you think copyright laws are in the UK? Okay, so you've got 5 choices here. If we could launch the poll, please, and you'll be given a choice of either A, over 100 years old, B, over 200 years, C, over 300 years, D, over 400 years old, or E, over 500 years old. Just going to give it a few more seconds. If we can, I can see that about 60% of you have answered. So just again, a little bit more time here to formulate your answers. Okay, any more for any more? Great. Okay, so I'm going to a couple more, just putting your answers in here. Okay, so I'm going to give you an overview of the results. We have, in answer to the question, we've got 14% of you think that copyright laws in the UK are over 100 years old. 42% of you think they are over 200 years old. 23% of you think they are over 300 years old. 7% over 400 years old. And 14% think that they are over 500 years old. Well, just close this off. I can tell you that in the UK being the legislative framework in which we have one of the oldest copyright laws in the world, the answer is that they are C, over 300 years old. So many congratulations to the 20% of you or so that got that correct. The Statute of Anne from 1709 was one of the most significant, most important pieces of copyright legislation in the world, because it really was the first time that copyright was dealt with on a countrywide basis, with an in-depth consideration about the impact of copyright, not actually on authors, but on publishers. It was very much driven by the publishing industry, which post-industrial revolution had seen an increase in their ability to produce the printed book. And this really was a response, the Statute of Anne, to trying to create a much more streamlined process and automated process for the protection of copyright in those works. Now, there have been many changes and iterations over the years, really what we have today, whilst it's, and you can see the sort of principles running through even since the Statute of Anne, and specifically subsequent to lobbying work by the artist William Hogarth, you can see the sort of threads still there. But the law we have today, the act that we refer to as the Copyright Designs and Patents Act of 1988, it's been amended and revised many times since it came into force in 1988. And again, with particular reference to cultural heritage organisations, some of the most significant changes were in 2014, the year 2014, which saw a wholesale upgrade to the exceptions to copyright, which we used to have. They used to be rather irrelevant, if you like, to what we were doing in the cultural heritage sector, but substantial amounts of lobbying by our sector and great successes meant that we saw changes to the legislative framework that enable us today to make use of copyright works to support not only our preservation objectives as cultural heritage organisations, but also in specific circumstances, the ability to use copyright works to support our activities. And again, I would urge you to find out more about these and how they affect your work. What I wanted to do next is to give you some more and greater understanding of the intellectual property rights family with particular reference to other family members, and then we'll start homing in on Creative Commons licenses. Okay, so a cousin of copyright. Some of you may be dealing with this as part of perhaps your organization's exploitation activities, are trademarks. Trademarks require registration really to get the maximum from the protection. You can have unregistered trademarks, but you would have to rely on the laws of passing off in order to prove any kind of infringements. The trademark does not have such a long duration of protection like copyright. It lasts only for 10 years. However, one of the benefits of having a registered trademark is that it's renewable ad infinitum. And indeed, some of the biggest brand names in the world, and I'll show you some of those in a moment, are protected by trademarks which are renewed on a regular basis, effectively creating an in perpetuity level of protection. Now, trademarks can take lots of different, can cover lots of different types of forms of logos, shapes, colors, sound effects even. And it provides a monopoly regarding the protection that you can benefit from within the goods and services in which you've registered it. So to give you a little bit of an overview of the types of trademarks that are protected, again, this is actually a very good example of the words of caution I offered at the beginning of this presentation, in that the content is available under a Creative Commons Attribution license, but please be very careful indeed about not reproducing any of these logos without considering the terms and conditions on which you can do them. Okay, so we have the Starbucks logo, the Apple logo, Marmite, BMW, and the National Gallery as examples of trademarks that are probably some of the most globally recognized trademarks in the world. So moving on to other cousins of copyright within the frame of the intellectual property rights family, we have design rights, which protects something's eye appeal. They, within their registered form, can last for 5 years and are renewable for up to 25 years. They're very useful for product design, fashion. You can see there's also reference to unregistered design rights, but these have a much more limited scope of protection. Patents, again, within the broader family of intellectual property rights, these protect inventions, goods or services that have the potential to be taken to market. They would also, patents have the benefit of protecting processes. Again, duration is limited for up to 20 years. And also there are certain requirements with regards to a patent's protection, which and the details are given here. And finally, I wanted to end this sort of overview of intellectual property rights family members with geographical indicators. And here there is a certain level of protection that can be used on products that have a specific geographic origin and possess qualities or reputation that are due to that origin. I'm sure you can think of others. The one that springs to mind, perhaps because it's not far off lunchtime, is the Cornish pasty, of course. Now, this is not a completely comprehensive list for you. There are other members of the intellectual property rights family, which I haven't mentioned, but I thought this was a useful romp through the landscape. And here really is an indication, in my opinion, of the manifestation of intellectual property rights across the cultural heritage sector. So you can see that by far and away, copyright and trademarks are probably the intellectual property rights that we are most likely to interface with. So where we are right now, the first 20 minutes of the presentation, I've set the scene, giving you an overview of intellectual property rights and also a sense of copyright within that space. And also I have started to drill down into the extent of copyright across our sector. I'm now going to move on really for the next, if you like, half of my verbal presentation today to explain to you in more depth about Creative Commons licenses. So Creative Commons licenses were a response to the international copyright landscape, which is very, very complicated. The reason is because whilst we do have international conventions and treaties and legislative provisions that are subsequently enshrined within each member state's legislative framework that reflect each other because of these conventions and agreements, copyright laws, I think it's fair to say, will vary from one country to another, even insignificantly, perhaps on the surface. The smallest difference can have a great impact, particularly when one is trading across spaces through the internet, whereby the internet acts as one big publishing platform. Okay, so this is one of the conundrums of the way that copyright works. Within this is the plain fact that the exceptions to copyright will effectively be different in each country. Again, on the surface, insignificantly, but the impact can be great on users and also on creators. European legislation aside, and the recent copyright directive that's being transposed into member states across the EU, it's a fair comment to make that it is a complicated space when there are country-specific laws and we are operating using an international publishing / trading platform. Now, Creative Commons were devised back in 2002 by Lawrence Lessig, who was an academic in the US, who envisaged the internet, the benefits of the internet and the challenges of copyright law as one of the factors for needing to find another way. He was greatly influenced by the open source movement, which is the sort of licensing mechanism for software, and conceived of the idea of the Creative Commons licensing framework, which is at core a very simple idea of creating what is effectively 7 different types of licenses that are available for free on the internet for anyone to use, to therefore make their work available not purely based on the exceptions to copyright, but actually setting in advance terms and conditions upon which that work can be used by anyone in the world under the terms of the license that the rights holder has selected for that work. The general concept is incredibly sound, and as I said, has been tested already or had been tested by the open source movement. By this point in time, there have been 4 different versions of the license, which have been drafted by lawyers from all over the world. And today we have therefore 7 template licenses that can be used on any type of work, digital or analog, as a way of pre-communicating to users of that work how the work can in fact be used. Now, the ambition is and was not only to make copyright laws effectively more digestible, but also to create more content that could be used by more people for free, i.e. a commons of content. Now, this has been achieved by some of the key terms hot-wired within the Creative Commons licenses. So the first is that any use of a piece of content which is licensed out under a Creative Commons license can be used in perpetuity, i.e. forever. The terms of the license are irrevocable. They can't be retracted by the person who's assigned the license. Royalty-free is another very important point about a piece of Creative Commons license, in that it is free to use. And the other side of the coin, of course, is that if you're wishing to embed your work with a Creative Commons license. And I use the word embed quite deliberately because you can embed the code within a digital form of your work. You can also use those licenses for free. And I should also add at this point that there are 3 different ways of communicating the terms of the license. Through the machine readable code that I've already referenced, a much lengthy legal code, and if you like, a synopsis on an A4 sheet of the terms under which that code has, license articulates the terms under which the piece of work can be used. And I think this is also a great strength of Creative Commons, in that the ease in which standardized licenses are communicated to users, i.e. that the licenses are user driven, is a really important point for minimizing infringements, because people don't understand terms and conditions, and ensuring that the sort of commons of content is developed and built, and more is added, because rights holders have the confidence that users understand what they're saying. A few other points to mention about the Creative Commons licenses: they are global, so anyone in the world can use content under the terms of that license. And then the next point is also quite important to point out, in that the licenses do not provide any kind of indemnification of the users if the person who's assigned the license doesn't have the rights to do so. And this is perhaps one of the downsides of using Creative Commons licensed material, which is the trust you as a user needs to have, or in the authority of the entity that's assigned that license. Creative Commons itself does not regulate the use of its licenses. Therefore, it's down to 2 different sort of bodies to decide whether the license is okay. First of all, the entity assigning the license to the work, and second of all, the user who is using that work. And unfortunately, if you are using a work that has got a Creative Commons license on it, for which the person who's assigned the license doesn't have the rights, then you as a user will also be effectively infringing the copyright. So this idea of trust and authority, and where to find content you know you can use under the terms of the license, becomes really fundamental. In other words, don't just Google it, find content with a Creative Commons license and think that's okay. You need to delve a little bit more deeply. And I will be going into this during the course of today's webinar, and looking at places you can go to find content that you can trust. And then a couple of other points to mention: that exceptions to copyright are unaffected by the terms of a Creative Commons license, and I'll pick up on that. I'll give you an example in a moment. And also the moral rights, those particularly that relate to the right to derogatory treatment of the rights holders, are also unaffected by the terms of the license. So to break this down, what do these look like? So I found an extremely useful chart online, which is licensed itself under a Creative Commons Attribution license, which summarizes, I think, rather beautifully the terms of each license. So at the very top, you have your sort of CC0, sort of effectively sort of public domain license. And this is very much, I guess, exemplifying the differences in how different jurisdictions work. So in the US, it's possible to put works in the public domain, and that would be your device, the CC0 license. In the UK, it's not possible to assign works into the public domain. If you own a copyright work, all that you can do is license it out and give the broadest rights to the users. So a CC0 would effectively act as a license under UK jurisdiction, public domain dedication in the US. And you can see the different sort of requirements, the difference really between CCBY, the attribution license, and the public domain is the requirement for attribution, obviously, if it's a CCBY license. And then we move down the list. The third on the list, the Creative Commons Attribution Share Alike license, is a very interesting one, in my opinion. It's the one that's closest aligned to some of the open source software licenses upon which, as I said earlier, the whole concept of Creative Commons licenses was built. Creative Commons Attribution Share Alike licenses are actually very open, in that someone who uses a work under that license can change or alter the work. They can use it if it's just the CC BY SA for commercial or non-commercial purposes, but the requirement is that any subsequent changes to that work, or indeed any reproduction of the work itself, themselves cover the CC BY-SA license. So some of you may have used some of the resources on our website, which are available under a Creative Commons Attribution Share Alike license. And what we're saying to you is, please reproduce these, please make them even better. But if you do anything to our resource or you republish our resource, we just want you to keep the CC BY-SA license on it. It keeps it in the community. It becomes a community resource. Looking down the list, the NC stands for non-commercial. Now, this is a really tricky bone of contention. Even the Intellectual Property Office recognised this a couple of weeks ago at the SLIP Copyright Conference when asked what is commercial, what's non-commercial, and they just pointed back to the Creative Commons definition of non-commercial. So broadly, non-commercial is, as defined by Creative Commons, anything, or commercial is anything that directly or indirectly leads to monetary gain or benefit, which is a sort of very sort of general definition of commercial. So I would say this is perhaps one of the most difficult challenges, is to determine whether what you're doing is non-commercial, particularly if your work is, say, in education or in a public sector organisation. I would suggest that to define what you're doing as commercial or non-commercial would probably, in those circumstances, be based upon the activity itself. So if it's, say, a marketing, some kind of marketing activity, or some kind of commercial generation that could be directly through sales, or maybe even visits to an exhibition which are being charged, then I would suggest that the NC non-commercial restriction may not be appropriate, and you probably should be looking for content which is either SA or BY. The other consideration I would also suggest is important is the ND. You can see this in the 4th license and also the 7th license. So ND stands for no derivatives, or if you, in other words, if you find a piece of content that has an ND, under the terms of the license, you're not allowed to change or alter it. But here, and I'm going to go back to a point I made earlier, the provisions in the Creative Commons licenses which state very clearly that the terms of the license cannot override any exceptions to copyright on the one hand, and together with the premise since 2014 within UK copyright law that there are certain exceptions to copyright, like the quotation exception, which cannot be overridden by contractual clauses, means effectively that you could still change or alter an ND, a non-derivative version of a work, or licensed under an ND version of the license, under, say, the quotation exception. Okay, so it's just something interesting. So no derivative does not always mean no. It depends on the context, and it actually depends if there's an exception that might effectively supersede that ND restriction. That's a real copyright geek's interesting thing to tell you. So how to choose a Creative Commons license. The best thing I can recommend to you is to go onto the Creative Commons website. I'm not going to give you a live demo. That's always terribly dubious to do during a live / recorded webinar, but I would strongly recommend that you click on the link here. And there's a really brilliant wizard that you can work your way through on the Creative Commons website. If you are wanting to make content available under a Creative Commons license, it helps you decide which is the Creative Commons license that's best for you. It also gives you guidance regarding attribution, or how you wish other people to attribute you if you're making that content is available under a Creative Commons license, and also gives you the code if you then wish to embed that license within your digital output. So that, in my opinion, is perhaps the most useful thing to use if you're wanting to think about the right Creative Commons license for you, bearing in mind the points I've raised already. So now it's your turn. Another poll for you. I wanted just to get a sense from you about how prolific are Creative Commons licensed materials on the internet. I've spoken a lot about the sorts of factors that mean that Creative Commons licenses are global, and the availability of the Creative Commons license. So could we have the poll launch, please? And you can select whether you think the answer is A, 2 million, B, 20 million, C, 200 million, or D, 2 billion. Okay. A couple more of you still to vote. Lovely. Okay. So 8% of you thought it's 2 million, 21% of you think it's 20 million, 47% think it's 200 million, and 24% is 2 billion. It's around the 2 billion figure. Okay, stacks and stacks and stacks of content online available under a Creative Commons license. That's not bad after 20 years of being launched. So well done, all of you. And let's sort of take a bit more of a view in terms of where you can go to find Creative Commons license materials. So some of the sector's contributors to this amazing wealth of content that you can find online, and also based upon the comment I made earlier about needing to trust the authority of the organisation that made that content available. So top of my list is Art UK. Art UK has been around now for many years, has done fantastic work across the sector in raising awareness about copyright and providing the tools and the support to make content available online, but also under a Creative Commons license. If you jump on the Art UK website, you will find a license picker which enables you to find content that they have available under different types of Creative Commons licenses, choosing the right licensed content to suit your needs. British Library as well has led the way. There are others on the list that have also done sterling work. So Wellcome has made tens of thousands of images available under Creative Commons licenses. Birmingham Museum and Art Gallery and also York Museums Trust get special mention from me for making out of copyright works available without any restrictions, and sterling work in raising the profile of their collections by doing so. British Cartoon Archive, National Gallery, Royal Shakespeare's Company, Science Museum, there's also not on the list, Natural History Museum, we have Tate, Imperial War Museums, etc. So a lot of organisations have made content available under Creative Commons licenses, and more are joining the endeavours to open up the UK's rich wealth of cultural heritage content. And this, to a greater extent, is very much due to the licensing position of the National Lottery Heritage Fund. So about 18 months ago, the National Lottery Heritage Fund refined its position within its terms and conditions of funding, so that any organisations that are recipients of its funding and generating sort of deliverables as a result, in accordance with the terms and conditions of funding, are required to make that content available under a Creative Commons attribution licence. This is a significant policy shift by the National Lottery Heritage Fund, and we'll look at some of the benefits of open licensing and actually this very broad position that the National Lottery Heritage Fund has taken. And what this means for you is that if you do receive funding from the National Lottery Heritage Fund to, say, for example, digitise your collections, you need to be aware that you have to put a Creative Commons license, a CC-BY license on those deliverables, unless you are able to discuss this separately with the National Lottery Heritage Fund and come to an alternative agreement. But it does mean specifically that if any of the content that you wish to digitise is itself in copyright, and the copyright is not owned by your organisation, nor do you have a licence to make it available under a CC-BY, you will need to go and get permission from any rights holders to secure the necessary rights that you can relicense their work out under a Creative Commons attribution license. And this is really important. In many cases, we work with organisations that have perhaps secured funding from the National Lottery Heritage Fund and haven't realised that this is a requirement of their funding. And by planning this into your schedule, planning this into your budgets and into your time, it's very possible to deal with the copyright issues within that content. But without having perhaps considered this at the beginning of your project, then it becomes much harder to find the time and the resources in order to deal with copyright properly and practically. Now, one of the reasons that the National Lottery Heritage Fund changed its position was to try and address the maximisation of the benefits of content to the broader global community. And in essence, the more open content is, the more that it's possible to enable and to empower access by anyone in the world, sort of breaking down all sorts of obstructions and obstacles and bridges. It's possible to ensure that images of works in our collections and other resources are used in the broadest possible way across educational contexts without any kind of issues, particularly as I mentioned earlier about the definition of non-commercial, and making works available under a CC-BY license particularly removes that, I think, real sort of difficult issue about definitions. It's possible to build upon resources. Other organisations are able to take with them and perhaps build all sorts of creative and innovative and entrepreneurial outputs. It expands the numbers of users of that content and enables all sorts of engagement through other platforms such as Wikimedia Commons, Wikidata. And you can see here as well that there is a strong public benefit for scholars and engineers, and the use of content under Creative Commons licenses, and particularly CC-BY licensed content across machine learning, computer vision and computational research. But of course, it's not just about what the public gets from Creative Commons licenses, it's what you as organisations get as well. How would you benefit? How do you benefit? And quite clearly, the organisations that have opened up their collections have a greater opportunity for public engagement. Images are able to virally spread over the internet, creating more interest in our collections, and also particularly post-lockdown, encouraging more people to come and see the real works themselves. I know that my sons, when we have been able to go back to museums, have been really excited by being able to see the real versions of images that they've only seen online. And of course, there are correlatory benefits, which is more media coverage, academic and public interest, more traffic to our websites, our digital platforms. It's possible that there are cost savings as well. And I know this is a contentious issue across our sector with regards to the cost of image licensing provisions and the benefits of image license provisions as well. And I'm certainly very happy to talk about this in the questions, but it is something that is a consideration, certainly. And of course, it's about encouraging, again, a more innovative use of content, not just by ourselves, but also by our peers across the cultural heritage community who are able to use our own images, perhaps to support maybe items that they have by the same creator in their collections. So lots here to unpick. There's been some great work done on open licensing by Dr. Andrea Wallace and Doug McCarthy, which I would urge you to read if you're interested in it. And in particular, a very important report written by Andrea Wallace over the last few months on behalf of TANC, that's Towards a National Collection, looking at open licenses and looking at some of the issues associated with it. So again, I think some subsequent reading if you are interested in this topic, and perhaps some of the issues and nuances which time restrictions today don't allow me to go into in any great detail. So before I open this up for questions and really keeping to the sort of 45 minutes time that I gave you, what are my top tips when thinking about Creative Commons licenses? Well, really top of the list is, if you are wanting to deliver content out under a Creative Commons license, please make sure that you think about the clearance of any third-party rights. Certainly when you go and get permission, or perhaps if you have permission already, to make sure that you seek permission that's at least equivalent to the Creative Commons license that you have selected to deliver that content out under. And interestingly, I was running a session yesterday for a learning forum, and I repeated the sort of mantra that I have, which is that when you are thinking about your projects and activities, please think about how you want your users to engage with that content before anything else, because that will then determine the course of copyright clearance. It's very, very difficult and not massively wise to think about perhaps the terms of use of content after you've created it or at the end of your activity. It's much more sensible to envelop this within the beginning and to think about perhaps a selection of content that suits the license upon which you want to deliver content under, for example. Please be aware that you can't put a Creative Commons license on a work that's out of copyright. A Creative Commons license is for use on a copyright work. That's what it covers. I'm sure many of you are aware of the problem of orphan works, and these are works in copyright where rights holders either unknown or cannot be traced. And in that respect, it's important to think about the strategy that you want to use for orphan works. Clearly, if you don't have the rights and you want to put a Creative Commons license on it, it becomes a matter of risk management. There is a risk management calculator that we developed a few years ago. The link is available on the resources page of the Naomi Korn Associates website. And if you are considering releasing orphan works under a Creative Commons license, it gives you an indication of the types of levels of risk. This is a really good example of the clash between practice and law, in that we have millions of orphan works across our sector, and how do we move forward from this position? But it is important to stress here that the role of risk management becomes ultra important if you're thinking about putting a Creative Commons license on that work. And then finally, please remember any specific terms and conditions from funders, from people that provide you with funding, perhaps to digitize your collections. And I've referenced the National Lottery Heritage Fund, but there are others that now are moving towards positions of requiring you to make your content available under open licensing terms, what this means for your project, what this means for your rights clearance. So you've got this sort of two dimensions, if you like, covered by this webinar. A, if you're wanting to use other people's Creative Commons license content, but B, what to think about if you yourselves are wanting to put Creative Commons licenses on your own content. Some useful resources for you: the National Lottery Heritage Fund Guide to Open Licenses by Andy Wallace is provided at the top. I've given you a link to the Creative Commons website, and also a very useful sort of wiki-like reference here to Open GLAM. So GLAM stands for Galleries, Libraries, Archives and Museums. I've also provided you with references to the Intellectual Property Office if you want to find out more about intellectual property rights. This project, the Heritage Digital Project, which we are very proud to be contributing partners with, the URL for the website's there, and you can gain access through that URL to not just some of the copyright resources I've signposted you to today, but also a lot of other fantastic work done by our partners on this project. And then finally, I would strongly recommend that you have a look at the brilliant website Copyright User, which contains just the most fantastically creative ways of explaining copyright and the exceptions to copyright. There are games there, and there are quizzes, and there are videos. It's absolutely stunning. So please do have a look at that. And it's really useful, perhaps if some of you are running training events, to signpost to some of the resources there. And finally, before I pass over to Thomas, who's very kindly agreed to moderate the questions, just to give you a few links to more information about us, our website. We're on Twitter, we are on Instagram, we're on LinkedIn, and you can also email us at info@naomicorn.com if there's anything we can do to help you, if you have any questions. So I wanted to thank you so much for listening. I hope you found this a very interesting 45 minutes. Lots here, I know, but hopefully this really just starts you off on your journey. And if I could invite Thomas to switch on your camera, and if you'd like to, as I said, moderate some of the questions for me. Thank you.
Yep, no, sure. Thank you very much, Naomi, for a fascinating presentation. So there's quite a few questions. I've got 6 so far, and people, please do keep adding them on into the Q&A box. That's a better way for me to keep track of questions we've got coming in. I'm going to try and do them in the order that they came in. So the first one, Naomi, is, are the country-specific exemptions where it is being used, or where was the work created?
Okay, that's it's generally where the users are based. Okay, so that kind of can be both. It's a really good question. Thank you very much indeed to whoever who's asked that. It's where, generally speaking, where the users are based. So if you're using something in the UK, then we are subject to the exceptions to copyright that are manifested in the UK's legislative framework, the Copyright Designs and Patents Act 1988, as amended and revised. If something goes online, that work then becomes subject to all the different users that could be based anywhere in the world. And there is some really interesting work that's been going on right now by a couple of amazing academics in the UK, Professor Tanya Alpen and also Dr. Emily Hudson, who've been looking at the extent by which some of the exceptions can be used, particularly the quotation exception, how far that can be used to justify using an extract of a work online because of the legislative provisions elsewhere in the world. If you are interested in that, there are some summaries of their work online, but that's quite specific. In general terms, exceptions to copyright do vary quite a lot. So what might be okay, say in a user in one country in the world, to do with a copyright work may not be okay for another.
Brilliant. No, thank you very, very much. I've met Emily myself. She's a fantastic researcher and quite a character. Would recommend reading some of her work if anyone hasn't read it yet. Another question that came through on the chat was about the non-derivative license. And the question was, if someone changes the license, say goes from non-derivative to a more open license, shall we say, does that affect all versions of that item that's been used? So can you post-date that change?
I think it's a problem because you can't, do you mean, I think it's a great question. Thank you very much indeed for asking it. I think it depends on the context, which is that if you yourselves have the rights to make that work available under a particular license type, and then you change your mind and want to put it out under another license, if that's what that license, if that's what that question's about, then yes, that's fine to do that. However, anybody that's used the content you made available under a Creative Commons license, under the license you selected previously, can still do so under the license because it's irrevocable. So how then to determine or how to differentiate between users who've used the work today and those effectively who've used it yesterday under different license terms becomes really, really complicated. If you are the rights holder or you have permission from the rights holder, my advice is that actually, if you aren't obliged to make content available under, say, a CC BY license, maybe if you're thinking about Creative Commons licenses for the first time, then maybe you might want to either run a pilot and see how it goes and see how content's used, or perhaps start with a more restrictive license and then gradually open up content. It's much harder to kind of rein back from a very open position unless you're 100% sure that's what you want to do. If that's what that question is about. The other kind of interpretation of the question I had is simply, if you are the user of the content, you can't change the terms of the license if it's, say, got an ND or an SA, because that's the whole point. The rights holder or the person with permission of the rights holder has put that restriction on it.
Super, thank you. Also on the point of CC licenses, there was a question that was asked that if you had a resource that you had available on your website, could you make it such that users of that resource would have to register, or would that be in conflict with the idea of a CC license?
I believe it would be in conflict with the idea of a CC license. The whole point is that anyone in the world can gain access to that content without having to sign any terms and conditions. So I think that is, I would suggest that at the very least, that would be in conflict with the spirit of what Creative Commons licenses are trying to do. And I think that if you are an organization that's requiring that, I would be interested to know what your worries or what your concerns are about using Creative Commons licenses, and based upon that, whether there might be another type of license that might be more appropriate for you. But the spirit of Creative Commons licenses, at the very least, is about non-discrimination. Anyone in the world can use that work. The only restrictions are that the work has to be done so under the terms of that license.
Fantastic, thank you. I've got a question that relates to some work we've been doing, Naomi, for some clients, and it says, it basically asks that you can't put a copyright, a Creative Commons license on a work that is out of copyright. But does that mean that the photo is so if you take a photograph, of a work that's out of copyright, does that mean that the photo is your work to make available under the Creative Commons? And does it make a difference if that work that you've taken a photograph of is 2-dimensional or 3-dimensional?
I think it depends. So there's, and I think for this, it's worth going back to the Intellectual Property Office's copyright notice from a few years ago, which was was giving a view. So this is not a sort of legally binding view, it's an opinion about whether there's copyright in photographs or not. And their view is that, and this is based upon sort of European Court of Justice rulings and case law, etc., but that copyright originality in UK copyright law means a creator's own intellectual creation. Okay, so it's really how far then a photograph is a creator's own intellectual creation. So as an example, last night we've just done, my family, we've just finished Stranger Things 4. Absolutely brilliant, just saying. And we're going back and watching the first series again. So any of you who've been watching Stranger Things, one of the lead characters is taking some photographs, I think in episode 2 or 3 of the first series. And those photographs are of sort of, very dark woods and people in woods. And the photographs would carry, in my opinion, would carry copyright because they are, original. They very much represent the photographer's own intellectual creation, that he has taken a photograph, he's lined the photograph up of his own, sort of according to his own interpretation of the world around him. Okay, that's straightforward, that's a sort of landscape shot. But I think within our sector, it becomes much more complicated because of our assertion in certain circumstances that, say, scans of works carry copyright. I would say that is something that is debatable at the very least. Also, how far a photograph of a flat work could itself carry copyright is also debatable. So I think the answer is it depends on context. It depends on how the photograph was taken. I think why the photograph was taken. I think that certainly under UK copyright law, there's a greater likelihood that there is copyright in a photograph of a 3D work. And in certain circumstances, 2D as well, depending upon what they are. So classically, Frank Albach's works are very sort of 3D. They're 2D paintings, but they're very 3D. I would say that taking a photograph of that work could well possibly attract copyright because of the sort of the nature of the photograph that's taken. So I think the answer is it depends on the context. But the sort of kind of our points of reference are, number one, the Intellectual Property Office's view about copyrighting photographs and the requirement that originality is a creator's own intellectual creation, number one, to justify originality. And I also think the second point of reference is, as I said in the webinar, that Creative Commons licenses are covering a copyright work. Okay, so they don't cover so data protection, they don't cover out of copyright works. It's about providing the means to use a copyright work, or in the case of the public domain dedication or CC0, to put something in the public domain, or under UK legislation, provide a very open license where effectively it is a public domain, effectively, because you're not asserting any rights, so to speak, in that licensed work.
Yeah, no, absolutely. I completely agree with the comments you just made about it completely depends, because it just draws me back to the Temple Island case in 2015, where you have the picture of a bus going across Westminster Bridge, and you think about how many tourists take a photograph like that every day. But it's if anyone looks up the case, it's such a distinct image, and it was found by the court to draw copyright into it. So no, it's very much depends, I think, is the matter.
It was seen to be an infringement, wasn't it, Thomas?
It was, yes. There were two images, basically one side by side, where you have a black and white image of Westminster Bridge with a very distinct red bus going across, and they had slightly different angles, but yeah, no, it was a copyright infringement. His Honour Judge Burse found so. That was
really, I remember that one really interestingly, and I remember sort of having quite a lot of debates with some of the participants in my workshop about that, whether that was very much almost taking copyright too far towards copyright almost effectively protecting an idea as something. The outcome was hotly debated by legal academics. Because of I think some of them found it quite a surprising outcome, but it is case law, as you said, Thomas, and I really thank you for raising that one.
My pleasure. Naomi, I'm aware of the time we're about to hit 12. I've got another 5 questions if you're happy to answer them.
Let's do them.
Cool. The next one is regarding the National Lottery Heritage Fund CCBY licenses, and it asks, if an organisation receives money for digitisation of a collection which owns the copyright, but has attachments to some of the materials that are in copyright but not owned by the organisation, can we still use the CCBY license if the in-copyright work is suppressed? It's quite a long question, I appreciate that.
No, it's fine. So if the in-copyright work is suppressed, so you're not making the in-copyright, I guess what you're asking is you're not making the in-copyright work available under a CCBY license. I think is that the question? I think that would then have to be something you discuss with the National Lottery Heritage Fund about whether they'd be happy for that. So that's those sorts of nuanced questions are to go back to the Nlhf, and they will be happy to have those conversations with you.
Yeah, I think from stuff we've also done in the past, it really depends on what the funding body comes back and says.
That's right.
Cool. And just the person who's asked the question apologised for the length of it and has now thanked you for answering it. So
no worries. And no, it's my pleasure. And thank everyone. Thank you so much for your questions as well. It's brilliant. So yeah, if there's any, fire away, Thomas. I think you've got another 4. Is that right? On your
yes, I do. I'm just trying to think of the best way. A lot of them about the CCBY licenses. Another question: does that mean that any imagery or video created during an Nlhf excavation will also be under a CCBY license?
I would imagine so, yes. And please do check the terms and conditions of funding. But it's very likely that if the funding was granted, I think it's post-September, well, 18 months ago. Do you know, it feels like lost 2 years because of COVID, but about 18 months ago in autumn, whenever that was, that will be, that's very likely to be under the new terms of CC.
Sorry, I think I accidentally mispressed a button there. Apologies. Further question regarding the Nlhf terms. Does it mean that with those changing those terms, does it mean that you can no longer license high-res versions of images while putting out low-res versions under a CC license?
There's been, I mean, this is the thing. So there's been, you can do it. You could certainly do that, but you would. I think there's been I think there is a strongly held view that the CC license is according to the work rather than the quality of the image. Right. So it's so you'd have to be aware that if it's low resolution, then yes, that's what you're licensing out. But I guess technically it would be for there wouldn't be a differentiation between the low and the high quality. So you would need to think about how that did affect your business regarding CCBY on your images. And I think there are also issues here about availability, accessibility, the relationship between, say, Creative Commons licenses and contract law in general as well.
Yeah. Thank you. And then final 2 questions I've got written down. If you are not able to use the CC BY NCND license for Nlhf projects, surely this opens up works to be used in an inappropriate way. That's the question. Does that kind of, if you're not able to use that license, does that open it up to being inappropriately used?
There is still you still got other types of law that are unaffected by a Creative Commons license. You've got defamation, libel, sort of if something is derogatory. So it still would enable you, if you felt that the work wasn't being used or is used in a way that would be obscene or defamatory, etc., to challenge. So it wouldn't stop you from doing that at all, because of other pieces of legislation that we have, or other laws that we have, and other sort of provisions in our legislative framework.
Also, I think, as you said, even if you have a Creative Commons license, that doesn't license away your own moral rights. So you'd have a route through those.
Yeah, absolutely. So there would be other sorts of means of recourse if you felt that a work was being used in any of those ways.
Brilliant, thank you. Sorry, I'm just reading over what we have. So there's one question saying, do the Nlhf Ccpy rules apply to all images held by an organisation that's received the funding, or just those created as part of the funded project?
I would suggest probably just those created as part of the funded project. But on a very sort of I suppose as a sort of comprehensive way of explaining this, Nlhf gives you money to do something which is going to result in a number of deliverables. Those deliverables that you've created using Nlhf money would require a CCBY license on them, unless you have conversations with Nlhf and they agree to something different. That's really what that means.
Superb, thank you. I've got one final question, and I'm going to have to cut it at that point, I think, given time. But we have one question in the Q&A box saying that if you acquire the right to show an image for display, can you share that image with another party to display? And my gut reaction to that would be no, because surely your license would be directly with you and not to extend to third parties. Although again, I guess that would depend on what the agreement says. Yeah. Am I correct in thinking that, Naomi?
That sounds good to me. Yeah, no, that sounds good.
I've learned something today.
I think that sounds good to me. Yeah, absolutely. So yeah, I think you can only really sub-license something if you have the rights to sub-license. I think that's really the bottom line. So this is, thank you so much for your questions. There is material available that I've signposted to that discusses in more detail the National Lottery Heritage Fund's position. This is the first link I gave you in the resources page at the end. I'd like to thank you very much indeed for coming along today to the webinar. I hope you found that useful, and again, if it hasn't answered all your questions, certainly helped you to formulate the right questions to be asked. I wanted to thank my colleague Thomas so much for magnificent hosting again, and also to thank Grace, who's behind the scenes in setting up the webinar, and colleagues as well at Charity Digital and our colleagues across the Heritage Digital Academy with regards to this series of webinars. So thank you all so very much indeed for all your time and for joining us today. Please watch out for the recording so you can listen to it in your leisure. But I'd like to say thank you very much indeed, everyone, for joining us, and to conclude today's webinar. Thank you.
Thank you very much.